Welcome. I am Tom Axworthy, Public Policy Chair at Massey College, and I'm here to welcome you to our ongoing series on Arctic issues and opportunities. Today, we are looking at the tremendously important issue of climate change litigation. The Arctic has been warming 3 times faster than the rest of the planet. And this then involves an enormous series of issues which has tremendously important judicial implications and the use of international law. So I want to thank the Polar Law Group, Massey College itself, the Bill Graham Center, and the Arctic Youth Network for joining with us in bringing together an expert panel drawn from Norway and Canada and appealing hopefully to you, a wider audience, to engage with these issues, to hear not only about the substance of climate change, but what international law can do about it.
Hello, everyone, and welcome to what I know will be a fantastic discussion of climate change litigation in relation to the Arctic. It's fitting for all kinds of reasons that the focus of our discussion is on the Arctic, not least because the region already experiences the impacts of climate change, and it does so and will do so to a much greater extent than other parts of the world. These factors aren't actually new. And so back in 2005, one of the first efforts to use, in that case, an international human rights law process to challenge the United States, at the time the largest national emitter of greenhouse gas emissions and just withdrawn from the Kyoto Protocol, was cast in terms of impacts of the rights, in terms of impacts on the rights of Arctic people. Sheila Watt-Cloutier, on behalf of the Inuit and supported by 2 US-based organizations, the Center for International Environmental Law and Earth Justice, brought a petition to the Inter-American Commission on Human Rights. The petition was dismissed because at the time the Commission considered it to be unclear whether the alleged facts would amount to a violation of rights. So one wonders what would happen today, 15 years later, with climate impacts at our doorstep and not just in the Arctic. What has happened in any case is that there's been a significant uptick in climate litigation of various kinds over the last few years. Actions by individuals or NGOs against governments, actions by individuals or NGOs against industry, also actions actually by governments, different levels of governments against industry, and of course, action by different levels of government against one another, currently in Canada, with provinces challenging the federal power to impose a carbon price. So there are a lot of avenues for litigation, but also a lot of obstacles. I'm sure we'll hear about both, and so I won't say more. I want to get straight to our panelists. We have a fantastic group of speakers directly involved in climate litigation assembled, and I want to thank each of them for taking the time to be here with us today. You can find out more about each of them via the event info, but let me give you a brief flavor of how lucky we are in order of appearance. Julia Olson is the founder of the US-based NGO Our Children's Trust, and she leads a high-profile constitutional climate challenge case, Juliana versus the United States, brought by 21 youth against the US government. Dagny Hovind is an associate at Glittertind Law in Oslo and is co-counsel on the Norwegian People versus Arctic Oil case. Gaute Eiterjord is campaigner at Greenpeace Norway and is also involved with the People versus Arctic Oil. Aslak, Hæka, Hætta, Bjørn is a Sami artist and activist and has been involved in Sami land rights and climate justice struggles for years. I'll now turn it over to Julia to get us started. She'll then pass the baton to Dagny and so on. And once we've heard from our speakers, I'll engage them in a discussion about their experience with climate litigation. So off we go, Julia. Over to you.
Thank you so much. And thank you for everyone who's listening in today. I'm going to show you a few slides as I walk through my presentation, and we'll start with the first one, please. Thank you. So I'm primarily going to discuss the case Juliana versus the US as a case study. Next slide. My organization, Our Children's Trust, we started a decade ago, and we are a public interest law firm that represents youth in the United States, and we support lawyers and youth abroad and also bringing cases against government to protect climate rights. We have these three principles you can see. One is that we only advocate on behalf of youth to elevate their voice on these critical issues. We advocate only for science-based and legally enforceable systemic remedies to the problem. And we use human rights laws as we do this. Next slide. So you'll see in this next slide, these are the Juliana plaintiffs. And one of the things that we do is we really try to connect with youth around the world to give them an opportunity to go to court and take action in the third branch of government. And one way we do that is by connecting with youth organizations and partners to really identify youth who are wanting to do more and youth who are already being harmed by climate change. And I'll talk more about that as we go. Next slide. So the thing to know about the Juliana case is it is a children's case. And the rights that we're seeking to protect in the Juliana litigation and all of our litigation are basic unalienable rights to life, liberty, personal security. All of these things include, of course, family autonomy, people's culture, subsistence rights, and so on. We're also arguing that children are being discriminated against, and they have rights of equal protection under the law. And last, our claims depend on an ancient doctrine called the public trust doctrine, which basically is the underlying principle that governments hold resources in trust for all of us and for the future. And those resources include our air, our water, and our climate. Next slide. So what I'm going to do is just walk you through some of the key moments in the Juliana litigation because it helps tell the story of the case. And one of the first early essential moments was back in 2016 when the trial judge ruled that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And that then set the stage for the Juliana case to move forward towards trial. Next slide. Unfortunately, as many of you probably know, through many twists and turns, we ended up on appeal, an early appeal, to the Ninth Circuit Court of Appeals in the US. And the questions that were addressed on appeal and that are now still pending are, can children and young people go to court to protect their fundamental rights? Do courts have a duty to actually hear these cases and make decisions about the rights of the youth and the obligation of government? And lastly, to kind of encompass what governments around the US and I think around the world argue is, does the political majority who's in power in government really have the freedom to make decisions that would destroy the climate, or should they be held to account by the judiciary? Next slide. So in January, we received a 2-to-1 decision from the Court of Appeals, and I'm going to walk through just a couple of key points from that decision, because it helps illustrate the important factual parts of the case and the story of the case. So this case is about government conduct. It's about affirmative conduct, not just a government's failure to act in a particular way. And as the majority, the two judges in the majority said, we had a substantial record that the US government had long promoted fossil fuels, despite knowing for over 50 years that it would cause catastrophic climate change. Next slide. And a central component of that, of course, is that the United States has been expanding oil and gas extraction, as I'm sure many of you know, including in the Arctic region. And both the majority and the dissenting opinion agreed that this posed an existential threat to the nation of the US, and it was actively being backed by the government. Next slide. This is just an image to show another central part of the stories of the cases, which is this is not a partisan issue. At least here in the United States, the responsibility for causing this problem lies with both Democrats and Republicans. And you can see over time that US fossil fuel production has gone up even under the Obama era. Next slide. So that takes us, to regions like the Arctic, where obviously the melting of the polar ice caps is causing sea level rise, the ice sheets in the Arctic. And one of the important findings by the court is that this melting may cause sea levels to rise 15 to 30 feet by 2100. And that was based on both government and other expert evidence that was in the record. Next slide. So, the information about the big picture impacts of climate change are critical in our cases. But the other thing that is critical that I mentioned early on in terms of how we bring youth into this work is really working with young people who can articulate and identify climate harms that are already happening to them. And so oftentimes those are based on physical or emotional health conditions, damage to physical property, youth who have had to evacuate from extreme events, and other types of harm that we bring forward through both the testimony of the youth and through our expert witnesses. Next slide. So as many of you know, it's been quite a season in the west of the United States, and we've had fires burning up and down the coast from Washington to California. And the majority opinion in the Juliana case recognized that if there wasn't action to stop climate change, it would cause these kinds of extreme disasters that we're seeing today. Next slide. This is a picture of Alex. He's one of the plaintiffs in the Juliana case, and he lives on a farm that his family has had for, I think, 4 generations now. And this was just a few weeks ago taken on the farm as the fires were burning, and we had the most toxic, hazardous air in the world. Next slide. So this is a really important slide, as is the next one, and it relates to the science-based nature of the work that we're doing in the courts. And that is when we're advocating for the human rights of young people and we're asking courts to set standards to protect them, we're looking to scientists to tell us what really needs to be done to prevent the melting of the ice sheets in the Arctic, for example. And what our experts, and I think a consensus of experts say now, is that CO2 levels above 350 parts per million are catastrophic and won't protect the ice sheets. Next slide. And so our work is focused on setting standards of 350 by 2100. 1 degree Celsius of warming is already too much, and we need to get back to that level by the end of the century. And there may need to be further reductions afterwards as well. I think most experts now recognize that if we really want to protect the ice sheets, that we need to get closer to pre-industrial levels of carbon dioxide. Next slide. So this has way too much text, I apologize, but I just wanted to illustrate some of the categories of the types of remedies that we seek on behalf of young people. The first and most important remedy in any climate litigation case is really a declaration of the law. This is, we're applying traditional laws, old human laws to a very novel issue. And having courts say that the law applies to the climate crisis and to protecting the rights of youth is vital. We also seek orders for remedial plans so that governments are required to prepare plans for how do we transition these energy systems, transportation, electricity, industrial, to clean energy so that they're reducing emissions at the national level or the state level in accordance with what science requires. And then we also have sought injunctions, so stopping further leasing of fossil fuel extraction, especially on public lands, and stopping the permission of new fossil fuel infrastructure. And of course, if we're successful in that, it would help shut down a lot of what the United States is responsible for, of course, in the Arctic. And then we ask courts to keep hold of the jurisdiction to oversee government compliance. Next slide. So right now, the Juliana case is waiting for a decision from our Court of Appeals. We've asked the full Court of Appeals to hear the case, which would be 11 judges, and we're waiting for that decision anxiously. And then from the Court of Appeals, the next step would either be trial or the US Supreme Court. Next slide. So this is just an example of some of the cases we're working on in the United States at the top. Those state cases are against the states of Alaska, Oregon, Washington, Florida, Montana. And then globally, we're supporting cases also around the world. Next slide. And one that we're really excited about that has been quite active the past 2 days is the case we support against the federal government of Canada, La Rose versus Her Majesty the Queen. And we just had 2 days of arguments in court on the government's attempt to strike the case or throw it out. And the judge was very engaged. It was a very interesting couple of days, and we're hopeful that that case will move forward to trial, and we should have a decision there in the next several months. So another case that is definitely bringing in the impacts across Canada and in the Arctic region. So thank you very much, and I look forward to the discussion.
So I think it would be over to.
Sorry about that. I'm transferring it to now Dagny.
To Dagny.
And also now with sound. Apologies. So yes, thank you so much, Julia, and thank you for having me on this seminar or webinar. So my name is Dagny Hovind, and I work as an associate with the Norwegian law firm Glittertind. The name Glittertind is after the second highest mountain in Norway. And as that name suggests, we are a firm that want to take environmental responsibility seriously. And this is also part of why we are engaged in this case. So I work as co-counsel on the case referred to here as People versus Arctic Oil, or the Norwegian climate lawsuit as we call it. And I work here in a team with 2 lawyers in charge of presenting the oral arguments here in Norway. One from Glittertind, so our firm, and another lawyer from a different firm. And we, of course, also work closely with the representatives for the environmental organizations bringing this lawsuit against the Norwegian government. These include Greenpeace, Nature and Youth, which is a Norwegian youth organization, Friends of the Earth Norway, and the Grandparents Climate Action, also a Norwegian NGO. The first 2 are the main plaintiffs in the case, whereas the second pair are the so-called co-plaintiffs. So Gaute Eiterjord from Greenpeace, who's speaking after me, is also the former leader of Nature and Youth. He will speak on behalf of the plaintiffs. And we have tried to split the main points between us to avoid too much repetition, and I suspect as well to prevent me from stealing his best material. Gaute will speak about the reasons behind the lawsuit and the background from the plaintiff's point of view. Whereas I, however, will be giving you just a brief summary of the case and where we are at now. I don't have any slides, but I approve the message of Gaute's slides coming a bit later. So I have worked on this case since 2018, and that's before the hearing in the appeals court. And before this, the case was also in the district court in 2017. And I have followed it closely since then because I also wrote my thesis on one of the questions in the case. So many people associate Norway with being a very environmentally friendly nation, but we are also a country profiting greatly from oil production. And this paradox is at the heart of this case. So the claim that's being forwarded is that the drilling licenses for new oil and gas exploration awarded by the government in 2016 in the Barents Sea, the Arctic, are invalid. And we argue that there are three reasons for this, three main reasons. First, the Norwegian constitution states that everyone has a right to a healthy environment, including our future generations. In addition, it says that the state shall take measures to secure this right. In the context of global climate change, we argue that these new licenses in Norway and in the Arctic are in breach of this constitutional right. Oil and gas extracted from these areas will necessarily result in future emissions into a world that needs to, and even more importantly, has agreed to, limit global warming to far below 2 degrees and aiming to limit it at 1.5. This is stated in the Paris Agreement. And these licenses, in addition, moves the oil and gas industry into vulnerable areas in the Arctic, where the nature is already heavily impacted by climate change. The government argues that this right to an environment in the Constitution is actually not a rights-bearing provision. The government says that this is only a duty for the state to work to safeguard the environment. This is one of the main questions for the Supreme Court to decide on. Both the district court and the appeals court agreed with the organizations on this point, that this article in the Constitution is a rights-bearing provision. But still, these two instances awarded the state a large margin of discretion in choosing how to work to protect the environment. Both instances ruled that the licenses did not breach the Constitution. Second, and also as a consequence of the mentioned argument from the state, the organizations argue that the licensing decision is also in breach of the European Convention of Human Rights. The climate crisis constitutes a real threat to the right to life and the right to private and family life, as enshrined in the European Convention. Instead of acting in accordance with its duty to safeguard these rights from the threat of global warming, the state is doing the opposite in granting these licenses. There are several decisions from the European Court of Human Rights which deal with environmental problems, but there is no case dealing with climate issues directly. In the Netherlands, however, the Dutch Supreme Court gave a judgment last year where they ordered the Dutch state to reduce its emissions by 25% within 2020. This was based on the convention rights, the right to life and the right to family and private life. This sets an interesting precedent for how national courts can use the convention to protect their citizens from the negative effects of climate change. Finally, we also argue that the government made several procedural errors in the process before granting these licenses. And as an example, there are several, but the main point is that the potential income to the state before opening this new area for exploration and extraction was grossly overestimated. And this is important because when you allow a large intervention with the environment, you usually do it for other reasons, for example, economic reasons. So overestimating one side of that scale is very problematic. And so to where we are now in this case. We are in the middle of it. The hearing before the Supreme Court will begin on the 4th of November this year, so only in a month. And the hearing will last for 7 days. This is longer than normal in the Supreme Court, and it's mainly because the Supreme Court has decided that they will hear the case in full. So this basically means we will go through all the facts and all the legal arguments from both sides in court. And I don't know how this is in the Canadian court system, for instance, but in Norwegian courts, the full arguments from each side are presented orally before the court. So this also naturally takes some time. And the court has further decided to hear this case in a so-called plenary session. And a plenary session means that all the justices of the Supreme Court, at the moment there will be 19, will hear the case. This is also rare in Norway, and it is a format reserved for very important cases. And I also want to mention that the plaintiffs have also been awarded free litigation for the Supreme Court. And this means that the court will cover the costs of this final round. There has been some discussion in the Norwegian public debate as to whether this is actually a case for the court to decide or whether it is a political issue, which is also something that Julia touched upon. We think that the Supreme Court accepting this case for a plenary hearing and also covering the organization's cost emphasize even more that the case belongs in court. And this is also, if you think about it, at least to me, quite natural. Because the main question in the case is whether the government's decision to grant licenses, moving the oil and gas exploration into new areas and further north than ever before, is valid. And the validity of public decisions can be challenged in court. And this is fully in line with and even at the core of the system of checks and balances. So to sum up, this case has received broad, both national and international attention. And this seminar is, of course, a good example of that. And we have also received several amicus briefs in the case, including from the Special Rapporteur for Human Rights and Environment, Mr. David Boyd, who is coincidentally also from Canada. So yeah, we believe that we have a very strong case, and we are excited to see what the Supreme Court decides. Thank you for the time, and I look forward to hearing the other speakers. And I'm passing the baton over to Gaute from Greenpeace. Thank you.
Thank you so much, Dagny. Hi, my name is Gaute. I'm very glad to be here to tell you about the Norwegian climate lawsuit. I've been working with the climate lawsuit since 2015. So I've been involved with the process from the start. And I also have some slides I wanted to show you to illustrate some of what our lawsuit is about. So yeah, we can just go to the first slide. As Dagny mentioned, Young Friends of the Earth Norway and Greenpeace Norway are the main plaintiffs in this court case, but we are also supported by a large coalition of other environmental organizations, artists, concerned scientists, and well, concerned citizens in general. And that has been important for us from the beginning, that we are not doing this just as Greenpeace or as Young Friends of the Earth Norway. We are a large group of citizens in Norway concerned with the environment. And then we can go to the next slide. So, as I mentioned, we have been working with this lawsuit for a long time, actually ever since 2014, when the Norwegian constitution was renewed and the environmental paragraph in our constitution, as we call it, was strengthened and given more content than before. And after that happened, that our constitution was updated, we had discussions in the environmental movement whether it was possible to have a climate lawsuit in Norway. Because for a long time we had been working to try to prevent more oil drilling in the Arctic in Norway. We had been to meetings with politicians, we had demonstrations, we wrote a lot of articles in the newspapers, but still we saw at every turn that the advice from the Norwegian Environmental Agency, for example, were not listened to by the government. They kept on giving licenses to drill for oil in some of our most vulnerable areas. And they kept on giving licenses to drill for oil when we know we have a climate crisis at hand. So then we decided that since we had tried everything else, we should also try a lawsuit. And I was part of Young Friends of the Earth Norway at the time, and we had a lot of discussion in our organization if this was a good idea or not, because, well, it is costly to have a lawsuit. It takes a lot of time. But in the end, we decided we had no choice, because it's what is at stake here is our future. And when we have a constitution giving us this right, we have to use to claim that constitutional right. Then we can go to the next slide. Dagny mentioned that the paragraph, and I've just briefly included it here as well, translated to English. The Norwegian constitution states very clearly that every person has a right to environment, and also that this applies to the future generations as well. But so far it's been mostly a thing that politicians have not cared very much about. It has not affected politics very much. But I think that will change now because of our lawsuit. The next slide, please. Because now we are seeing the effects of the climate crisis. We are seeing the effects of many decades of lacking action from politicians. This picture I have added to the presentation is from a newspaper where I'm from in Norway. And in Norway, as in many other places in the world, we have been experiencing more extreme weather than before. And especially in the summer of 2018, there was a lot of wildfires. Our farmers experienced the worst dry season in history. And I think many people, and especially young people, are now feeling personally that their future is at stake because the politicians are not doing enough to combat climate crisis. Then we can go to the next slide. I've included some figures in the presentation just to show what we're trying to do with this lawsuit. Because, as Dagny mentioned, Norway is often looked upon as a country contributing to solving the climate crisis. We have a lot of electric vehicles. We are paying many countries money to not chop down their rainforest. But while we're doing that, we're also making lots of money selling oil and gas to the rest of the world. And what this figure is showing is how large the emissions from Norway are. That's the column on the left. And also how large the emissions from oil and gas produced in Norway are. And as you can see on the figure, the emissions from oil and gas produced in Norway are 10 times as large as all other emissions in Norway. So this is what we often talk about as the Norwegian paradox, that we want to solve the climate crisis, but when it comes to, when we sum up all that we do, we are a net contributor to the climate crisis. Then we can go to the next slide. And the International Panel on Climate Change has been, in their latest report from 2018, they said very clearly that we have a limited budget of how much emissions we now can emit into the atmosphere before we are crossing the threshold of warming over 2 degrees or 1.5 degrees. And what this figure is showing is how much emissions are now in the oil and gas fields and the coal mines that companies are planning to extract. And as the figure shows, the oil companies and coal companies and gas companies of the world are planning to extract way more fossil fuels than we can use. if we're going to reach our climate targets. And for us, that's why it's so wrong of Norway to keep looking for more oil and gas, because the oil and gas licenses that this lawsuit concerns, we're not talking about oil and gas production today. We're talking about oil and gas production maybe 10, 15 years in the future. So we're talking about just adding more and more fossil fuels to a column that is already way too large. We already have way too much. We should, instead of looking for more oil and gas, as possible, make us not depend on these energy sources anymore. Then we can go to the next slide. And this is just a last figure to show that Norway really is not a good guy in the battle against climate crisis. And what this figure is showing is which countries in the world are exporting most emissions. And Norway, while being a country of 5 million people, which is not a very large country internationally, we are the 7th largest exporter of emissions. So even though we are a small country, our climate impact on climate is very big. And that is something that we want to address with this lawsuit. Then we can go to the next slide. Originally, I had a map in this presentation of where these oil licenses were, and a map of the Barents Sea. But then I realized if you're not from Norway, a map of the Barents Sea is not going to tell you very much. So instead, I've tried to show you where in the world are we when we talk about these oil licenses. And as you will see on the map, Norway has a long coastline. And when we pass north of the Norwegian Sea and into the Barents Sea, we are entering Arctic waters. And this is the area that Norwegian politicians now think will be the next big money maker for Norway. This is the area where we now have our most of our oil and gas that we haven't extracted yet. And we as plaintiffs in this climate lawsuits think that we should not open these new areas now. We can go to the next slide. Because since we are now in Arctic waters, it's not the same as extracting oil and gas further south. This picture here is from actually from further south. It's from outside the capital of Norway, Oslo, where there was an oil spill from a tanker a few years back. And the oil spill happened while there was ice on the waters. And it was a huge challenge to try to clean up that oil spill. And this was in almost perfect weather conditions. Still, the nature was very badly damaged. And this is just, this is nothing compared to what will happen if there is an oil spill in the Barents Sea in the Arctic. So that's another reason why we feel that these oil licenses are violating our constitutional right, in addition to contributing to more emissions. We can go to the next slide. So yeah, why have we decided to have a climate lawsuit? As Dagny mentioned, a lawsuit like this is unique, and in Norwegian law we have never seen anything like it. So if it turns out we win this lawsuit, it will be historically, because never before have politicians in Norway been forced to cancel oil licenses because of climate concerns. And that will be a huge win for both the Norwegian environmental movement and I think also the international environmental movement. Next slide, please. So Dagny mentioned a little bit about the judgments and what we have experienced so far. And I think already we have made history with our lawsuit because, well, this constitutional right has been acknowledged as a right by a court. And the state did not agree with that at all. So the state attorney have already faced a huge defeat. But of course, we want the state to be found guilty. And so far, we have at least two large fights to win in the Supreme Court. And one of those fights is that we need to get the court to see that Norway has a responsibility for the oil and gas that we are selling to other countries, creating emissions. The court has not agreed on that yet. And also another battle is the Constitution states that the state should ensure the environmental rights of all citizens. But what we need to do now is get the court to agree with us that the state then should not allow for more oil drilling, because now the court see this constitutional right as they say that the state is given quite a lot of leeway as how to achieve that right. What we need to know now is in the Supreme Court is get the court to say it's a clear the oil drilling is a clear violation of the right. There is boundaries for how much damage you can do to the environment. I think maybe that was the slide. No, I think I have one more slide, so just go to the last slide. Actually, there are two more slides. I've talked now a lot about the case and the facts, but what this lawsuit really is about the right to a healthy environment for me and all other citizens in Norway, but especially for children and youth. And this picture here is from the 22nd of March last year, where more than 40,000 pupils in Norway decided to strike school because the politicians were not doing enough to combat the climate crisis. And the climate strikes have really given a voice to the young people. And what we're doing with the lawsuit is the same thing. So even though we are now, because of the pandemic, not able to gather in large crowds as we did last year with the climate strikes, we are now taking the same battle in court. And then I think we can go to the last slide. So I was just thinking I should finish up with talking a little bit about the effect that the lawsuit has already had. Because even though we have not won in court yet, I hope, already the climate lawsuit has created very much public debate about oil and climate that we have not had in Norway before. I think already that is a big win for us, that more politicians and more people are saying we should not look for more oil. And actually, some of the oil companies that own these licenses to drill for oil, they have decided to postpone or cancel oil drilling in these areas. They have not said it was because of our lawsuit, but I think some of the attention we have made with the lawsuit have made them realize this is not going to be as profitable and as popular as they thought it would be. I think more and more also oil companies are seeing that they need to adapt. It's going way too slow, but still through these kind of lawsuits, we are creating pressure. I think in the end that will also change the politics. So thanks so much. That was my brief introduction about our climate lawsuit. And I will now pass the stage on to Aslak.
Thank you, Gaute. It's always interesting and engaging and informing to listen to you. My name is Aslak Hæka Hætta Bjørn. I'm a Sami artist and activist, and by day I'm an advisor for the Norwegian Sami Association. And we are the largest political and cultural non-governmental organization for Sami in Norway. And I'm honored to be invited to this session today to share some Arctic indigenous perspectives. So I would like to share some perspectives on the threat climate change posed to Sami as an Arctic indigenous people, and give some reflections on the climate change litigation in the Arctic. And to start with my background and the background of the Sami people, we are an indigenous people situated in Northern Europe. Today, Sami are spread within the borders of the countries that are Norway, Sweden, Finland, and northwestern Russia. But we've been hanging around in the Fenno Scandinavia since the ice caps withdrawal. So we've been around for a couple of years, longer than the modern nation states. And as many other indigenous peoples of the planet, the Sami way of life, our spirituality and our livelihood is closely connected to living by the land and living in nature. And we have traditionally lived by hunting, gathering, fishing, and reindeer husbandry. And the reindeer pastoralism is of huge cultural significance to the Sami people. The reindeer pastoralism is a carrier of our culture, and to some Sami communities, it's both a cultural and really an existential precondition, as language and culture and tradition are passed down through this livelihood. And even us who are not involved in reindeer husbandry or have gathering of nature as our primary livelihoods, we have a strong cultural attachment to this way of living, if it is fishing in the rivers or picking your seasonal mountain of cloudberries. So nature and living by the land is of huge importance to the Sami personally, but also as a culture. And moving from cloudberries to the climate change litigations, climate change is obviously an existential threat to all of mankind, but we see that indigenous communities, really all over the globe, are often on the front lines of climate change. And for the Sami people, there are two factors really coming into play here. And the first is that our culture and our livelihood is so closely connected to nature as it is. But our geographical situation is also a condition and a factor, as you see that, climate change is happening in the Arctic, and the Arctic is where we maybe see the effects of climate change first. And even if this is especially true in the Arctic, I think that you see it all over the globe, that indigenous people are those who are first affected by climate change. And at the same time, indigenous people are hardly to blame for climate emissions. So it's kind of a deadly paradox there. And as a Sami residing in Norway, and as a hangaround and ex-member of the environmental movement in Norway, I've been paying most attention to what we here refer to as the people versus Arctic oil case, or the climate litigation, as we probably just say in Norway. And I think it's really interesting that it's going to the full Supreme Court now, and I'm really stoked on the fact that it will be a free litigation. And as Dagny said, this case from the start primarily concerns the Norwegian people's right to a healthy environment under the Norwegian constitution. But I think that it's also a human rights case, more and more so, as I understand, in the litigation process. And from a Sami perspective, I think it's helpful to view it as a human rights case as well. And it's because one argument against the Norwegian climate litigation that is often heard is that it's hard to show how exporting exporting fossil fuels from Norway will deteriorate the Norwegian people's right to a healthy environment. Like, who knows, maybe it will be worse off to be a Norwegian in the future. which obviously is scientifically false. But in the Sami context, there's no question on whether or not this climate change is infuriating personal and human rights. We feel it right now, and our future is at stake. The Sami are often called the people of the 8 seasons, as all of our traditional activities are so closely interlinked with the passing of the year that 4 seasons won't do. We have to split the year into 8. And what you see is that climate change is messing up all of these seasons. And for the reindeer herders who are traveling with their flocks of reindeer from the inland to the sea through the year, these changes are really visible. You have problems where land get locked, as we say. If snow comes early in the fall, but then melts again, and then it gets cold, barrier of ice is over the ground, making it impossible for the reindeers to get to the lichen that they need to live. And for people living off traditional coastal fisheries, you already see now and know that this will get harder through the years due to climate change, as cod are migrating from the coasts and further north and further into the oceans, making traditional coastal fishing nearly impossible in the future. And while this is happening, the Norwegian government are searching for more oil to burn. We all know that this is the stuff that drives climate change, and that this is the stuff that messes up the seasons and our livelihood. And as I mentioned, you could make a case or make an argument that the effect from burning fossil fuels to losing the ability to live your life is not that clear if you are living in cities in southern Norway. But this effect is really clear in the Sami context. In our context, the effect of rising climate emissions have a real clear effect on individuals. Because how is a Sami reindeer herder, or a herder community to be able to, for instance, enjoy their culture, which they have the human right to do under Article 27 of the International Covenant on Civil and Political Rights, when climate change are taking their livelihood away? And what about the Sami family's right to a family when they are losing the livelihood that they have depended on for centuries? Is that not a violation of Article 8 in the European Charter of Human Rights? I will certainly say so. So yeah, I think that's an important perspective for us. And I think, yeah, I'm really happy that the human rights angle of the climate litigation have been more and more outspoken for each step of the way we have come in the judicial system. There's another debate that's been going on in the Norwegian discourse about the climate litigation, as Dagny referred to, and that is the democratic legitimacy of using the courts as litigation. Is this politics, or is this something that we should do in the courts? And from a Sami context, we do not frown upon taking cases like this to the courts, because this is both in a human rights perspective and in a constitutional perspective. I see it as a rights litigation, and rights have to be cleared out. Do they actually have a meaning, or are they just vague goals? And if they're just goals, they shouldn't be in constitutions. So Sami have used the Norwegian constitution, the Norwegian litigation system in our land rights struggles. And it's obviously like a symbiosis of political work to get past new laws and the work done in the courts. But I think that the effect of landmark cases are really important in these rights questions. Yeah, I think I'll end my talk here. And I don't think I'll set the stage for a new speaker, but I'll probably pass it back to our moderator. Thank you.
Thanks so much, Aslak. I think you just reinforced what all of the speakers have said very clearly, that this whole debate is not really an abstraction. Climate change is not an abstraction that should be obvious to all of us, given what's happening, not just in the Arctic, but everywhere, including on the west coast of North America in terms of fires. But I think each of you has really underscored that this is about people and impacts on people and their rights. So what I wanted to do is to enter into or take a sort of a look at the issues that you've raised from a number of different angles. So one question that I'd be interested in hearing from each of you, or any one of you who'd like to comment on it. So I mentioned in my opening remarks the 2005 attempt by the Inuit to use the Inter-American human rights system to raise climate change as an issue. And the obstacle, one of the obstacles they ran into ultimately was the assessment by the Commission that the harm was too prospective. There wasn't enough of a connection there yet to harm to rights. So I'm wondering whether are we now at a point where that argument actually cannot be made anymore, or are you still running into that kind of argument? And then slightly more technically, what is actually required? Is it necessary to show that rights of specific individuals are already being injured, or would it be sufficient to show, for example, that there is a significant risk of this harm occurring? So I'll just lob that out there and I'll see who wants to run with it.
I'll jump in with that. I think it's really critical in climate litigation to show how young people or whomever the plaintiffs are, Indigenous peoples, are being harmed today, because harm is occurring. And so bringing the right stories into the courtroom to describe the harm today, but then also talking about how that harm is going to be exacerbated in the future if heating and emissions continue. I think both are really critical. We have to make what's happening tangible for judges, and people are being harmed already, and it will only get worse, as we know. So I think it's a really critical component of litigation.
Dagny, yeah?
Yes, thank you for a good question. The short answer to whether this argument is still being made is definitely yes. At least in our case, that argument is definitely on the table. Both instances, both the district court and the appeals court accepted that the constitutional right to environment is a right, and they also accepted that risk of breaching these rights are enough, so to say, that there is a threshold of what risk you can actually accept to the citizens. But then, of course, the margin of discretion was also set so high that these licenses did not breach in the court's view. So, but I also just wanted to say shortly, it was just a comment actually to what Gaute said. I'm not sure, I think he said the right thing, but I just wanted to clarify that the appeals court actually did accept the fact that Norway has the responsibility for emissions from Norwegian produced oil and gas that is burnt abroad, which was a major step from the district court, where the court did not accept that argument. So that will also, of course, be a very important point to strengthen even more, but also to of course get the Supreme Court to agree to that as well as the appeals court did, which is of course in our view completely natural, since the extraction takes place here and the decision is being made here. So yes, shortly, thank you.
That's great. I see that Aslak wanted in, but I have a sense that Gaute wants to respond specifically to the point that Dagny just made. So if that's okay, I'll get Gaute in and then go to Aslak.
Yes, thank you. Yes, what Dagny is saying now is, I forgot to add that, because that's what happened in the appeal court is quite historic in Norway, because not many politicians here wanted to take any responsibility for what the emissions that come from oil and gas produced in Norway when it's used in another country, and we now have a judgment from the appeal court saying that it is relevant to look at this. That has never happened before, and I think if we have the same level of improvement in the Supreme Court, maybe this can work. But yes, Dagny is saying the connection between the decision to allow oil drilling and breaching the constitutional right, that to make that connection is one of the most difficult things to have the court do. And I think then it's really important to both in court and outside court, when we talk about these lawsuits, to talk about that this is about actual lives, actual people's lives. And I think our Children's Trust has done a really good job of doing that. In Norway, one of our largest talk shows, Skavlan, had a participant from our Children's Trust as a guest a few years back, and to talk about this. And I think we have much to learn from our Children's Trust in how you have done this, how you have managed to get the stories of the young people out. Because that is, in a sense, what our lawsuit is also about.
Great. We'll turn it over to Aslak.
Yeah, you asked if the conditions have changed since the last Indigenous climate change litigation. And I think that, like, factually, we have to admit that it has. Climate change have become really visible in the Arctic for the last 12 years. And will probably continue to do that. And in some context, at least, you can see that. What I think might be barrier or a problem to get the courts to do is akin to a problem we've seen in indigenous human rights litigations in Norway, where you are talking about nature and environment as the material basis of culture. That, as someone who are not a judge or as a social activist or someone outside of the judicial system, it's not hard to see how climate change is affecting people's life to the worse, how it makes it harder to live off nature, harder to be a reindeer herder, for instance. But we see that we have this threshold of showing that if this should indeed be a human rights violation, you have to be able to point to this one person who have lost his livelihood or been denied his right to culture due to climate change or due to land grab connected to development projects. So I think that is a challenge. I think that our children's trust and the climate litigation Norway as well has done a very good job to illuminate how people are affected actually by climate change. But yeah, I just want to address that challenge.
I see Dagny once in yet again, so here we go.
Yeah, I'm sorry if it's yet again. It was just to what was said earlier about the risk and whether that's enough. I just think it's also good to point out that it's a paradox if you take a case of risk of climate change damage to court, it will be it can be and will be argued that it is too hypothetical. But when that risk materializes, it will then be too late to actually stop the damage. So I just think that's an interesting point.
I'm on mute. See, there we are. Technology. The point that you just made, I think, is really important and really powerful. And I also wanted to strike the yet from what I said a moment ago, because what we want to do actually is get you engaged in a discussion. So it's great that you're jumping back in. So let me put another question out that also gets at what I take to be some of the difficulties that one might encounter in court, or some of the hesitations that courts have in engaging in these engaging with the arguments in these cases. So let me put the question like this: how do you frame a case so that you build the court a bridge to overcoming the hurdle that comes up, I think, a lot about government discretion to deal with complex situations? And I assume you've all thought about this question and found an approach to dealing with it. And in Dagny's, in your presentation, Dagny, you made as one of the arguments, you highlighted that there was also a procedural argument. So I wonder to what extent it can be helpful, albeit perhaps less satisfying, to go at this on a procedural level. Or I'm thinking here also of July's decision by the Supreme Court of Ireland that quashed the Irish government's national mitigation plan because the plan wasn't in keeping with the requirements of legislation. And so there's it's a different type of litigation, of course. It wasn't about human rights or people's rights, but it made it a more sort of conventional legal argument for the court, and safer perhaps in some respects. So how do you deal with this issue in the way that in the kinds of cases that you're bringing? And again, open to anyone to jump in, including Dagny.
I'll start us off with what we've done in our cases is really look to other systems that infringe on people's human rights. And the approach that our Children's Trust takes is that this is a systemic problem, and that the system that governments put in place needs to be challenged as in violation of people's fundamental rights. And so, for example, in the United States, we have cases that challenge prison systems and the way they operate. We have cases that challenge systems of public education that are discriminatory. Sometimes foster care systems cause harm to children, and that's another example. So there are all kinds of case examples in different places about systems being implemented in ways that are harming people. And so in our litigation, we've tried to take it outside of specific project contexts and tell the story of the whole system that is causing the problem. And that can pose challenges for sure, to have a court sort of grasp the totality of the system that is causing the violation. But I think it's an important part of the story. You know, it's interesting just to on a little side note here about the Arctic oil case is the amendment to the Norwegian Constitution, Section 112. The inspiration for that began actually at the very inception of our Children's Trust when Paul Lorentzen, a lawyer from Norway, came and met with us, and we started talking about the principles of the public trust. And he helped craft that provision of the Constitution to really safeguard not just present generations, but future generations in Norway. And he and others did that to set up this precise litigation that we helped support early on. And I think the key point for courts is that they are the last check. They're our last hope right now when the political branches of government are continuing through decisions like the ones to open up the Arctic further for oil extraction, or just keeping these systems in place that we're all locked into with energy production. The courts are the last check on that abuse of power and making sure that that power is held to account to protect human rights. And I think the Supreme Court of Norway should really be looking carefully at this provision that was always intended to give real meaning to the people of Norway and protect them and their future.
Dagny, yes?
Thank you. I just would like to add, or to the two questions, I think it were. One, the margin of discretion cannot be wide when the risk is so high and the damage will be so dramatic, is sort of the main argument on that point. And to the second point, procedure is crucial to environmental protection because when you accept or an intervention in nature, it is, as I said also earlier, because of something else, a different interest, and you're weighing them against each other, and so the procedure has to be fair, and that is very tightly connected to the material side. So in this case, these two things are very connected. Thank you.
Good. So let me go a slightly different direction and ask, I take it, if I understand correctly, that both of the cases we've talked about here are cases that involve groups of individuals as plaintiffs. So that, I assume, also was a deliberate choice to do this as opposed to, say, a class action. And Sir, I don't know whether that's maybe more a question for Julia. I don't actually know what the class action situation in Norway would be like, but I know in Canada there have been attempts to bring a class action on behalf of youth, and that ran into difficulties with the class being ill-defined and so on. So I'm wondering whether you have any thoughts on that.
We haven't gone the class action route in our cases because it's more time intensive and there are more processes involved. And again, we're really trying to get the individual stories of youth in front of the courts. And I think, you know, the young people, like the 21 Juliana plaintiffs, they stand for all youth in the United States who are being currently harmed by their government. And so we've just found it to be a more straightforward and streamlined way to go to court. But the individual voice and the individual story and the individual harm is critical to all of our cases.
And does that expose the plaintiffs to a risk of costs, or is that not so much a consideration?
It's a consideration in certain jurisdictions. So we carefully evaluate that, and we try to protect plaintiffs and families from any risk of liability in that respect. There are certain countries like Canada that do have some fee and cost shifting, but in public interest cases, you can sometimes avoid that liability. But in most jurisdictions where we practice currently, we don't have that kind of risk because of the public interest nature of these cases and just the laws of the jurisdictions.
Anybody else, or should I go in a different direction yet? All right, let me take that as a different direction yet. It's quite different in the sense that I'm wondering, some of you have made passing reference. I think, Aslak, you've made most reference to international law. So I'm wondering, how relevant is international law in your efforts to bring climate change before the courts? So at some level, that could be the Paris Agreement. I think there was passing reference to the Paris temperature goals. But you, Aslak, mentioned in particular human rights, the ICCPR, and I'm also wondering whether the UN Declaration on the Rights of Indigenous Peoples plays any role, and how you weigh bringing a human rights action or making a human rights argument as opposed to an Indigenous peoples' rights argument. So perhaps we'll start with you, Aslak, if that's okay.
Yeah, thank you for that question. I think that in the Sami context, we tend to look at both like litigation processes, but also political processes through the lens of international law. And well, the reason is that most of indigenous policy and institution in Norway is based on the fact that we have signed the ILO 169 convention. And international law practices and articles as the principle of free, informed, and prior consent from the UN on indigenous peoples are something that we always use in our argumentation for Sami rights cases. The concept of free, informed, and prior consent might be harder in a climate context, I guess, because the damage done isn't done on indigenous lands necessarily, but maybe rather in the sea. So I think that if you are going to use the indigenous law, international indigenous law process here, or like line of argumentation, you'll have to see on human rights articles as the right to family, the right to culture under Article 27, and the right to life and health. Yeah.
All right, anybody else on the role of international law? Okay, so I have Gaute and then Julia.
In the Norwegian climate lawsuit, our case is, well, it's about the Norwegian law, and we reference the Paris Agreement as in the case, for example, the temperature goals, but well, it's important to us to stress that we are not saying in our case that Norway is formally violating the Paris Agreement, because that agreement is so non-binding. It's difficult to formally violate it, but we are violating the goals in the agreement and the agreement when we are not doing our share of what we have committed to. But what we are violating is our constitution. Then also we, as Dagny mentioned, the European Convention on Human Rights has become a more important part of the constitution. But and those rights are also reflected in the Norwegian constitution. I think maybe this is a little bit law technical answer, but our basis is the constitution, and I think maybe it's I'm not an expert in the field, but I think maybe it would be difficult to have this lawsuit on international law. But then the international laws are often the basis of what we have based the constitution on.
All right, Julia.
Yeah, thank you. I think for most domestic lawsuits, domestic law tends to be the best hook. There are some countries that are better at recognizing and following and holding themselves accountable to international laws and conventions and treaties. The United States is not one. And I think some of the biggest polluting countries in the world are not as compliant with those types of agreements and processes. But all of those, the Convention on the Right of the Child, or the Declaration of Indigenous Peoples' Rights, and the various climate treaties, what they are helpful for is to show the persuasiveness of these legal arguments and the need to protect young people's and Indigenous people's human rights in the face of the climate crisis. So we bring them in for that global context, not for a specific claim. And again, since you referenced it, I'll just highlight that in our view and in the view of the experts we work with, the targets set by the Paris Agreement are dangerous. So allowing warming up to 1.5 degrees Celsius or 2 degrees Celsius would be catastrophic. And I think this is a really important point for lawyers. And that is, when we put standards in law, whether it's through a court process or a statute, and we say we will allow something up to a certain point, governments will take full advantage of that. So if the standard we set is 1.5, you can bet that as a world, we will go to 1.5. And you can bet that the ice sheets will melt and that the forests along the west coast of the United States will burn, and Indigenous peoples will lose even more than they already have, and our children will suffer. So I think it's just very important that as lawyers and advocates and as youth bringing these cases, we think really carefully about what we're asking courts to set into law and what truly protects human rights. And even if we're concerned about our ability to stay within those targets or those limits, in my view, we should not be putting into law targets and standards that are dangerous.
Well, that is also a pretty powerful closing statement. So perhaps I will just leave it at that and thank each of you for your initial presentations, but then also for the really interesting discussion we've just had. And at this point then, I want to introduce one more participant in our event today, Tora Fougner-Økland. She's a biologist and environmental activist and a member of the board of Young Friends of the Earth Norway, and she has a call for action for us. So thanks everyone, and let's listen to Tora. For your initial presentations, but then also for the really interesting discussion.
All right, can you hear me? So thanks so much, everyone, for staying with us right now until the end. My name is Tora Fougner-Økland, and I'm a central board member and activist at Young Friends of the Earth Norway. And I've been given the honor of wrapping this whole thing up and giving you some pointers for where to go if you want to stay a little bit connected with this case, how to get more involved. So first of all, as you've heard by now, Young Friends of the Earth Norway is one of the plaintiffs in this case, together with Greenpeace. We're also the largest youth environmental NGO in Norway. And also 100% youth-led, I should say. So everything that goes on in our offices is done by people under the age of 30. And right now, as you've heard, we're gearing up for our final round in court. And we have local groups all over the country which will be part of this preparation because we really want to emphasize that this is action coming from all over the country. And you've heard a little bit by now about how this case has gone from maybe being viewed as a PR stunt or by some maybe a practical joke rather than a serious and desperate attempt to demand climate action from our government and climate action that they have promised us. And it's gone from that to being something that's considered so important that it's given a plenary session in the Supreme Court, it's given free litigation, and has gained wide support nationally. And this is, in my opinion, to a large part due to a wide show of support and solidarity. So it's become really clear that this is not Greenpeace versus the government or youth versus boomers, but it's actually the people versus Arctic oil. And that's a really important point. And it's something that we've been able to do by, showing support across political factions, across generations, and also across borders. And that increases the legitimacy of the case, that climate action isn't a hobby, it's a fundamental need for our future. And of course, we hope that this means that if we win, that gives more hope to climate litigation cases across the world. And it will certainly send shockwaves through the oil and gas industry. And that's why it's also important for us to engage people all across the world, because the struggle for a livable environment, of course, doesn't have borders. And Norway needs to know that the world is watching. And that when we say that we want to be a leader on climate action and protecting biodiversity, that we actually need to follow up on home ground. And that's why I'd like to invite anyone watching us now to join our Global Action Day, which will be the day before this case starts in court. You can find more information about that and sign up for our global action groups if you go to our webpage, which I'm not going to say because it's in Norwegian. It's much easier if you just Google people versus Arctic oil and you'll find it that way. You can also connect with us on social media, of course, but there you'll be able to find ways of signing up for this Global Action Day. And I really hope you'll join us there. I'd also like to thank our sponsors once again. Thank you to Massey College and the University of Toronto, the Polar Law Group at the Faculty of Law, the Bill Graham Centre for Contemporary International History, Arctic Youth Network, and of course, thank you so much to our panelists, all of you, Julia, Dagny, Aslak, and Gaute. Your insights have been very valuable. Thank you for your time, and it's been wonderful to have such a broad discussion around this. So thank you very much, and thank you also, of course, to Professor Brunnée for your moderation and your insight as well. And finally, I'd like to give a virtual applause to the team that's been organising this, which I know has taken a lot of time. I think you should be proud of your results, and of course to everyone who joined us online. For everyone who, if you know there's someone who wasn't able to join us today, you can tell them that this will also be made available on Massey College's YouTube page. That also applies if you want to see this thing again. Many wonderful insights that deserve to be repeated, I think. And finally, remember to check out our Global Action Day. So thank you so much for joining us, all of you. And be sure to tune in to see how this case develops further. Thank you.